So the 8th Circuit will now review the GOA and 17 state lawsuit against the ATF and their new rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, if you agree that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are also huge Second Amendment supporters. So if you want to support an amazing company and also get some coffee along the way, I highly recommend you check out Blackout Coffee, and I will leave a link to them down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, GOA along with 17 states have requested an appeal from the 8th Circuit in their lawsuit against the ATF and their new rule on frames and receivers. This comes after just a couple days ago when a federal district judge denied a motion to enjoin the enforcement of that new rule on frames and receivers, which took effect on Wednesday. GOA, along with the 17 states, were trying to get the North Dakota federal judge in the case to recognize how the new ATF rule will infringe our Second Amendment rights and those rights protected by the Second Amendment. And they also argued that the Supreme Court's new ruling in Bruin also indicates that the district court there in that case should have enjoined the enforcement of this ATF new rule until the full trial can actually happen. However, this district court judge denied the motion and instead agreed with the ATF that a preliminary injunction should not be granted. Therefore, the frames and receivers rule went into effect on Wednesday of this week. GOA in the 17 states have now requested that the 8th Circuit review this issue and ultimately find that the district court should have enjoined the new rule on frames and receivers from ever taking effect. Now, I know some of you may be interested in who those 17 states are that are part of this lawsuit. I've mentioned it before in another video, but for those curious, it's Arizona, West Virginia, Alaska, Arkansas, Idaho, Indiana, Kansas, Kentucky, Louisiana, Missouri, Montana, Nebraska, Oklahoma, South Carolina, Texas, Utah, and Wyoming. And they are the ones who joined this lawsuit by Gun Owners of America. Now, if you're not aware of what this lawsuit entails, this lawsuit is against the ATF because of their new rule on frames and receivers. The new rule by the ATF is essentially a restriction on the sale of 80%er kits. Under this new rule, 80%er kits are treated as actual firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references so that 80%er kits are actually defined to be actual firearms. Since 80%er kits are considered to actually be firearms under this new rule, they are then subject to serialization requirements and background checks as well. Under the new rule, the primary impact is on gun stores and gun manufacturers of these items. An FFL or gun store will now have to serialize all those 80%er kits that they have in their inventory, and also they will have to run background checks on any 80%er kits that they sell to customers who come in and wanting to purchase them. As for manufacturers of these items, they will also be greatly impacted by this new rule. They are also required to serialize all the kits that they manufacture and sell, and also they are going to be required under this new rule on frames and receivers to be actual license holders, so they have to have an FFL license. So that's a general rundown of what this new rule on frames and receivers did, and that is what's being challenged in this GOA lawsuit along with the 17 states who are also suing the ATF. Now, this case was filed in North Dakota in a district court. The plaintiffs requested that the district court judge grant a motion for a preliminary injunction to stop the ATF from enforcing their new rule, which was set to take effect Wednesday, August 24th of this week. A preliminary injunction is simply a request for an order from a court which will prohibit an action from taking place, and essentially it is to preserve the status quo until the court can actually review the entire case and until the whole case is actually decided. However, on review, the district court judge here, Peter Wilt, found that under Bruin and other concepts as well, an injunction was not warranted in this case. In his own words, he stated, "However, as recently as 2 months ago, the Supreme Court declined to weigh the government's interest in regulating firearms, which distinguishes Heller and its progeny, at least to some degree. As an initial matter, while not specifically argued by the plaintiffs, the court believes that the ATF's response to the Second Amendment concerns brought up during the notice and comment period to the notice for proposed rulemaking was sufficient. As noted in the final rule, concerns regarding constitutionality of the proposed rule were raised by multiple comments." He went on to state that the ATF appropriately responded by indicating its belief that the proposed rule was consistent with the Second Amendment's jurisprudence at the time the final rule was drafted, and explained why it is. It is difficult to fathom what more the ATF could have said in the response at the time, as it could not have predicted the future development in the law. Turning to the substance of Bruin, that case concerned an unconstitutional proper cause requirement for issuance of concealed carry permits in the state of New York. quite distinguishable from the facts here, he stated. Nonetheless, the question is whether the final rule would pass constitutional muster post-Bruin, where, as the court reads Bruin, an individual's right to keep and bear arms for self-defense may not be arbitrarily denied by a state. From the outset, however, it is crucial to note the final rule concerns the commercial sale of firearms. The final rule does not infringe on any individual's or business's ability to completely manufacture a firearm for personal use, nor does it restrict the ability to obtain the weapon kits at issue. Instead, he stated, the final rule simply requires serialization of a firearm when it is in the stream of commerce so that it may be tracked in the event a crime is committed with the firearm. There is a long-standing distinction between the right to keep and bear arms and commercial regulation of firearms sales. As such, in this court's view, the final rule was and remains constitutional under the Second Amendment. Despite the multitude of arguments to the contrary advanced by the plaintiffs, the court cannot conclude they have met their burden of showing the final rule is not in accordance with the law. As such, the plaintiffs have not demonstrated a likelihood of success on the claims. So the district court judge in this case believed that the Bruin decision does not impact the ATF's new rule, since during the notice and comment period, the ATF made claims and responses to why they believe the Second Amendment is not implicated by this rule. The issue with this is that yes, Bruin requires the government to justify their restrictions, but they must do so pointing to history and tradition dating back to 1791. Also, it is the job of the court to review if that justification is correct. Here, the judge simply seems to defer to the ATF since they made some sort of vague claim that the Second Amendment is not implicated. The court is actually supposed to look at their justification and see if it dates back to 1791, if it is a historical analog or basis for this restriction, and then make their determination. Not simply just say, well, the ATF put forward some sort of justification whatsoever, therefore we're going to uphold what they did. No, they are supposed to actually look at that justification. Another concerning thing this judge did was he tried to cabin Bruin as if it only impacts proper cause standards and concealed carry permits. He says this issue is in contrast to those decisions by Bruin and that this case is about commercial sales and therefore it does not infringe on any individual or business rights to keep and bear arms, and so he's saying that the Second Amendment does not actually touch on this issue. He also says that this is not a complete ban on the purchase or the making of these types of firearms, therefore it is not actually implicating the Second Amendment as well. To me, that's type of an argument that's akin to what you see some liberal courts say. For example, when magazine bans, they try to say, well, this is not a complete ban on the purchase and possession of magazines, only magazines that hold more than 10 rounds, therefore it's lawful. Here, this judge, along with other judges who've accepted arguments like that, failed to recognize that any restriction on the sale of items can violate the Second Amendment. It doesn't take a complete ban for there to be a violation of the Second Amendment. So as you can see, the judge here in this case looked at Bruin, but ultimately determined it has no impact on the ATF's new rule on frames and receivers. As a result of that, and that denial of the motion, GOA in the 17 states have filed an appeal for review by the 8th Circuit. So the ATF's new rule on frames and receivers is now likely headed to the 8th Circuit Court of Appeals for review. This will be the first case post-Bruin that a circuit court will look at the ATF's infringements and decide what impact Bruin has on those actions. So we'll definitely be keeping our eyes on this case because it's going to have huge implications on what actual application or what type of enforcement this new rule on frames and receivers has. Right now, the new rule on frames and receivers is in force and effect, but we still have lawsuits like this one, Morehouse, which are seeking Circuit Court of Appeals review to try to stop what the ATF is doing. So if we get any more information, I will let you all know. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.